Dear students, today in this video, we will look into the topic lease under the subject property law. I am Lalith Kumar, Assistant Professor of Law, Bharat Institute of Law, Bharat Institute of Higher Education and Research, Chennai. So first we will look into the definition of lease, which has been defined under section 105 of the Transfer of Property Act 1882. So a lease of immovable property is a transfer of a right to enjoy such property made for a certain time, which may be expressed or which may be implied, or in perpetuity in consideration. So these are certain considerations. So it might be a price paid or promised to be paid, or any money, or a share of crops, or any service, or any other thing which has a value. So it depends upon the concerned lease agreement or lease deed that what the consideration is. It can be any one of these following types of consideration. It can be a price paid, or it can be a price which has been promised to be paid. It can be in the terms of monetary, that is money, or it can be a share of crops if the lease agreement is related with some agricultural land, or even if not an agricultural land, it can be related to the share of crops is concerned, or any service, or if let's say that particular person to whom the lease agreement has been entered upon, he's doing some business or he's providing some service, that service can be availed by you. So let's say you have uh, a place or a vacant land which you have given for a car mechanic. So now what you're doing is you are seeking consideration in amount of service. So what you're doing is every month you're just giving your car or your two-wheeler for service to him. So he will do it free of cost for you. So it is like he's not going to pay you the rent, he's going to deduct the same from your service cost which has been incurred for your vehicle. Okay, so this is called as lease. So which has to be rendered periodically or on a specified occasions to the transferor by the transferee who accepts the transfer on such terms. So it has to be paid periodically, or it has to be on any specified date which has to be agreed upon by the lessor as well as the lessee as of a lease deed is concerned. So these are certain important terms as of lease is concerned. That is the transferor here is called as the lessor, the transferee is called as the lessee, the price is called as the premium, and the money, share, service, or other things to be rendered is called as the rent. So the price will be called as the premium, the transferor is the lessor, the transferee is the lessee, and the money, or let it be share of crops, or let it be service, or any other things to be so rendered will be called as the rent. Now we will look into the rights and liabilities of lessor and lessee. That also comes under section 108. So in this video, we will be looking into the rights and liabilities of the lessor. Okay. So these rights and liabilities are applicable in absence of an agreement or any local custom to its contrary. So if there is no agreement between the parties, or let's say if there is no local custom as of that particular agreement is concerned, then section 108 will be applied. So it comes from subsection A to subsection Q of section 108. So we will look into the liabilities first. As of the lessor is concerned, we will look into the liabilities of the lessor. The first one is duty to disclosure, which comes under section 108 subclause A. So it provides that the lessor is bound to disclose to the lessee any material defect in the property with reference to its intended use of which the lessor is aware, but the lessee is not aware. So any material defect to which the lessor is aware, that the lessor has the knowledge that there is a material defect in the property, then the lessor is bound to reveal the same to the lessee. And defects are of two types, an apparent one, a latent one. So the lessor is bound to disclose latent defects because such defects cannot be discovered with ordinary care. So apparent one is which is visible as such. Any layman can tell that there is a defect in this. But a latent one is something which has to be found out with an ordinary care or with a person who is expertised in that field. So let's say you're standing in front of a two-wheeler and the two-wheeler is punctured. So the moment you see it, you can easily tell that the two-wheeler is punctured, but you will just see the tire and you will just see that the tire is flat. So you will say that either there is no air in the tire or the tire is punctured. So this is called as an apparent defect. A latent defect, let's say there is a fault in the engine in the two-wheeler. So just because by seeing the vehicle, you cannot find out that there is a fault in the vehicle. And let's say you are driving it, some may find out, some may not find out. If you're used to driving two-wheelers and you're having some knowledge on that, then you can say that there is some defect in the vehicle, though if not particular one. But if a mechanic drives the same, he can easily say you that what defect it is, because he is a person who is expertised in that particular vehicle or in that particular field. So such things has to be revealed. If you know that, if you have that knowledge that there is a defect, a material defect in the property. For example, only I was giving you the examples of movable property, but we are looking into as of an immovable property is concerned. And the duty of disclosure is especially important where the defects affect the right of enjoyment or the use of the property itself. So the lessor is bound, as I said you, the lessor is bound to disclose the material defects with reference to the intended use of the property, but he is not responsible for a defect of which he is himself unaware. He is not aware about that defect, or which the lessee is aware or could with ordinary care discover. So if you find out that anything is there, so if you find out that anything is there, any defect is there, as a lessor, you are bound to tell the same. But let's say if it is an apparent defect, which the lessee he himself can easily find out, there is no need, there is no duty on you to go and reveal the same. It becomes the responsibility of the lessee to look into that. It becomes the responsibility or the liability of the lessee to look into the property before entering into an agreement. So for example, let's say you're going and buying a product. So it becomes your duty to make sure you check all the whether all the features are working or not. Let's say you've just blindly you just bought the property and let's say the product, and you come to your house and you find out that there is a defect. Now you're also responsible. You are also equally responsible. So that becomes your duty. Buyer, be aware. So as a buyer, you should be aware before buying a property or before buying any product, to make sure to check whether these things, or what are the things which will be covered under the warranty or the guarantee, or if there is a warranty being provided or not, or what are the years, for how many years they are providing it, and all those things. It becomes your duty to make sure that you go and ask these basic things while buying a product or any other basic things as of a property is concerned. The next one is, the next liability is to give possession, the duty to give possession, which comes under section 108 clause B. The lessor is under a duty on the lessee's request to put him in possession of the property. And if he fails to deliver the possession to the lessee, he cannot recover rent or enforce the obligation of the lessee under the agreement. However, the duty of the lessor to deliver possession only arises when there is a request by the lessee in this request or in this context. So the lessee, there are few case laws in which the points have been highlighted also. That is, the lessee has a statutory right to compel the lessor to put him in possession of the leased property. It was held in the case KC Route versus the state of Orissa. So what it says that once you enter into an agreement, it becomes a liability of the lessor to give the possession to the lessee. Or let's say it becomes the right of the lessee to claim the possession of the property which has been leased upon. So by granting a lease, the lessor undertakes to put the lessee into the possession, and it does not matter that the lessor has not got possession himself. So it becomes his duty to make sure that the possession is given. And the lessor is not liable unless the lessee makes a request. So it is, though it is the right of the lessee, he has to claim it. If you're not going to claim it, then it means that you're waiving your rights as per the Indian Contract Act. You're just waiving your rights. You're not using your rights for which you're entitled to. So it is your right. You have the right to claim it. The moment you claim it, it becomes the liability of the lessor to give the possession to the lessee. So as a lessee's point of view, you will have the right, and as of a lessor point of view, it becomes a liability. And if the lessor fails to give the possession, let's say if the lessor has failed to give the possession to the lessee. The lessee can maintain a suit on his lease for possession against the lessor and against the third person who may be in possession. So let's say if the lessor has given the possession to a third person, then he can file a suit against the lessor as well as the third person who is enjoying the possession of that property. It was held in the case Ahmedar Rahman versus Jameen Rajan. And the lessor is not entitled to rent unless and until he has fulfilled his obligation to put the lessee in a possession of the land leased out to him. The next liability is the covenant for quiet enjoyment, section 108 clause C. So this clause provides that if the lessee pays rent reserved by the lease and performs the contract binding on him, he may hold the property during the time limited by the lease without any interruption. So the covenant implied by this section is the absolute covenant expressed in an English lease. The express covenant of an English lease is either absolute or unqualified, restricted or qualified. So this was explained in the case Narong Singh versus Make. So I'll tell you what was the actual explanation given in that case. So a qualified covenant for quiet enjoyment protects the lessee against the interruption by the lessor, his heirs, and assigns or any other person claiming by or under him, them, or any one of them. An unqualified covenant protects the lessee against the interruption by the lessor, his heirs, and or assignees by any other person or persons whomsoever. And the distinction is that the qualified covenant does not cover eviction by title paramount, while the unqualified, that is, while the absolute, so when it is qualified, it is the restricted covenant, and when it is unqualified, it is the absolute covenant. It does not protect the lessee from the title paramount. And in cases decided under the Transfer of Property Act, the implied covenant under this subsection has been held to be an unqualified covenant, protecting the lessees from the title paramount. So the covenant implied under this section 108 clause C protects against lawful and not tortious interruptions. And next, now we will look into the rights of the lessor. So the first one is right to assertion, section 108 clause D. So if during the continuance of a lease, any assertion, accession, or addition, if any addition is made to the property given by a way of lease, such assertion or accession or addition shall be deemed to be comprised in the original lease. So the addition may be natural. Sometimes it may come through flood or at the expense of the lessee, or maybe a tree which might have been planted by the tenant. And however lease, the lessee cannot have title to such assertion, and lessee should surrender the assertion after the period of tenancy. So you have to give back whatever addition you are making in the property, provided if it is something which can be removed without damaging the property, you can do so. But if it is something which will damage the property, then you will not have a right to take it back. So let's say you have got a godown for a lease, and now what you have done is you have erected certain slabs, or let's say you have erected certain bookshelves for your business, or let's say you have just kept some chairs, or you have just kept some cabins and all for your employees. Now the moment you're vacating, you can easily remove all those things and you can vacate the property once the lease agreement comes to an end. But let's say you have made some changes, some major changes to the property, which if you're removing might damage the property, then you will not have a right to remove those things. So without damaging the property, if something can be done, you have the right to take so. Right, so you have the right to make the assertion, as well as you have the right, provided with the consent of the lessor is required. You cannot just like that go and make any changes in the property and all. So to be an assertion, it is necessary that it should be an imperceptible addition, but it must be a gradual and not a sudden one. And when the lessee encroaches upon neighboring land, so let's say you're going to get a easementary rights, it is deemed to be an assertion. And if the lessee requires a prospective title to the assertion, the lessor gets the benefit to the assertion at the end of the lease period. So let's say if the lessee is there for a period of, let's say 20 years, and he is enjoying the part of the land of the neighbor. So now he has got the easementary rights over the neighbor's land. And the moment when you are selling off your property, easementary rights alone cannot be sold off. We have seen under section 6 of this act, which says what property may be transferred. The nomenclature reads so, but when we look into the section, it says property of all kind can be transferred except, and one of those exceptions is the easement. Easement rights alone cannot be sold off. So when the lease period comes to an end, the lessor will enjoy the land, that is the lease land, and as well as the easement right which the lessee was getting, because easementary rights moves with the land. So when the land comes to back to the lessor will be able to enjoy both the land as well as the easementary rights. The easementary rights cannot be taken away by the lessee, stating that I had got that addition to the property and all. You will not have a right to say so. Next is to avoid lease, section 108 clause E, or we can also tell it as destruction. So in the case of the destruction of the subject matter, so when the subject matter is destroyed of the lease, the lessee, if he is not able to be blamed for such destruction, could avoid the lease at his option. So that becomes a voidable contract now. So now let's say you have leased a particular house and now it has been destroyed by one or the other natural calamity. Now it is up to the the lessee. He can accept it and he can move on with that, or he can avoid the contract and get back the money which has been paid upon. So it is at the option of the lessee. So it is a voidable contract in such nature. So in case where the whole rent has been paid in advance and the property is destroyed before the period of lease, then the lessee has a right to recover the proportionate part of the rent which has been already paid. So let's say we have seen in the definition clause itself that the rent has to be paid periodically or any special occasion. So let's say you are paying the rent yearly once. Now let's say you have paid the whole rent in the month of Jan itself. Property gets destroyed in the month of June. Now you have not enjoyed the whole year property. You have not enjoyed till the month of December. Now you can deduct the first 6 months till June, and for the next 6 months which has been already paid, you have the right to get back that amount. You have the right to go and claim the same. That is the right which this section gives you. So where the tenancy is exclusively for the premises and not for the land, on the destruction of the subject matter, the tenancy stands extinguished. And the destructions of the premises by the landlord is not an act of God, and section 108E does not apply. So suit by the tenant for directing the landlord to restore the possession in the original condition is maintainable. And this clause was held not to apply when a house was damaged by earthquake so as to need repair, but it was not in danger of collapsing. And the clause also does not apply when a godown was destroyed by the fire caused by the negligence of the lessee's watchman. The next is to charge for repair, section 108 clause F. So this clause provides that if the lessor neglects to make any repairs which he is bound to make to the property, so certain repairs, certain wear and tear do happens in the property, and whatever as per the terms and conditions, sometimes it can be that the small wear and tear has to be borne by the lessee, then he is bound to do so. The major repairs or major any problems in the property, let it might be something related to the drainage system or the sewage system or to the electricity. So if it is a minor one, then the lessee has to go with that, or he has to go with those expenses. And if it is a major one, the lessor will do so. It's up to the agreement. It's up to the agreement. But let's say if there is no agreement, and if it is natural wear and tear in the property, then the lessor is bound to do so. The lessor is bound to repair those things. So to charge for repair. So if a clause is there, this clause provides that if the lessor neglects to make any repairs which is bound to make to the property after notice within a reasonable time, then the lessee may make the repair himself, and he can deduct the same from the rent or from the interest, whichever is applied for that particular lease, and he can recover it from the lessor. So the lessor is not bound to make repairs, but if he is agreed at the time of the lease with the lessee that he will make the necessary repairs, then he becomes bound to make the repair. So it is, as I said, it depends on the lease deed alone. So if you are agreed, if you are bound, or if you are agreed, or if there is a terms and condition which says that the lessor is bound, then you are bound to make those repairs. And if you are denying it, or if you are neglecting it, then the lessee can do the repairs, the whatever repair is required for the property, and he can deduct the same from your rent. So it becomes his right. Okay. So the lessor is under no liability to repair in the absence of an express contract. So it has to be an express contract making him liable. So it was held in the case Bolton versus Donald. So, and the lessor's covenant to repair and the lessee's covenant to pay the rent are independent covenants. Okay, and if the lessor does not make the repairs, the lessee himself can do and deduct the expenses after notice to the lessor. It was held in the case Ishwar versus Sudarshan. And the next is the right to make payments, section 108 clause G. So this clause provides that if the lessor neglects to make any payment which he is bound to make, and which if not made by him is revocable from the lessee or against the property, the lessee may make such payment himself and deduct it with interest from rent or otherwise recover it from the lessor. So if the lessee makes a payment which the lessor is bound to make, so if he is making any payment, so let's say if it is an property tax or a sewage tax or water tax, any tax which the lessor is bound to make, and at that period of time the lessor has neglected to make it, or the lessor was not in a place to be contacted, or let's say he was not in a state to be contacted, or let's say he was out of contact for a period of time, you are bound to pay the property tax. So what the lessee will do is the lessee will pay the property tax, and in return he will recover it from the lessor. He can get it back from the lessor, or he can deduct the same from the rent amount which he was doing for the repair charges. So the lessee may make such payment himself and deduct it with interest also, he can do so from rent or otherwise recover it from the lessor. So if the lessee makes a payment which the lessor is bound to make, and which if not made is revocable from the lessor or from the land, or the lessee is a person interested in the payment and is therefore entitled to be reimbursed. So this is enacted under section 69 of the Indian Contract Act 1872 itself. Reimbursement of persons paying money due by another in payment of which he is interested. So that person, the lessor is interested, so the lessee is making, then the lessor is bound to give it back to the lessee. So it is there in the Indian Contract Act section 69 itself. And payments under this section may be government assessment or ground rent or rates or taxes applicable by the landlord, which was held in the case Basant Lal versus Bora Ram. The next is the right to remove fixtures, section 108 clause H. The lessee may, even after the determination of the lease, remove at any time while he is in the possession of the property leased, but not afterwards, and all things which he has attached to the earth, but he must lease the property in the state in which he has received it. So this clause explains, this clause provides an exception to the general rule that things attached to the earth becomes a part of it, which we have studied in the definition clause of the immovable property under the same act, Transfer of Property Act 1882. So in Dhairavan versus J.R. Thakur, it's a case law in which this section was explained, and it was explained in this way that a lessee can remove all structures and buildings erected by him on the demised land, and all that was necessary for him to do was to give back the land to the lessor on termination of the lease in the same condition as he found it. So you have to give back the property in the same condition in which you have received it. Okay, it might be a building or it might be even a land also. So the lessee has the right to remove the building by the contract they had agreed to and hand over the same to the lessor without the right to receive the compensation at the end of the lease, the matter being entirely one of the contract between the parties. So the matter entirely lies as per the contract or as per the agreements. The right to have the benefit of crops, section 108 clause I. So when a lease is of uncertain duration and the interest of the lessee is determined otherwise than his fault, the lessee is entitled to the benefit of all the crops growing, planted or sown by him. The lessee or his legal representatives have been given the right to ingress and egress to visit the leased property to gather and carry the grown crops. So where the lease is of an uncertain duration, where the lease is not for a determined period or for a certain period, then what happens? Then the lessee's interest is determined. The lessee's interest is determined, and it is to benefit of all the crops growing on the land which has been planted or sown by him. So that applies for the agricultural land. So this section has been described as representing the common law of India, because in the initial stage, in the 1882 periods and all, we were used to be more into the agricultural sector. So it is been, the section represents the common law of India. And the next is the right to assign his interest, section 108 clause J. So in the absence of any contract to the contrary, this section empowers the lessee to transfer absolutely or by way of mortgage or sublease the whole or any part of his interest in the property. His transferee or assignee may likewise transfer his interest. However, the lessee shall not, by reason only of such transfer, cease to be subject to any of the liabilities attached to the lease. So where there is no covenant, so where there is no agreement restricting the rights of the lessee to assign his interest, the lessee's rights are heritable and transferable. And a relinquishment is different from an assignment of tenancy. So in the case of an assignment, the assigner continues to be liable to the landlord or to the performer of his obligations under the tenancy, and this liability is contractual. And in the absence of the contract, no consent of the landlord is necessary for the assignment. So we have seen the rights and liabilities of the lessor, and we also have the rights and liabilities of the lessee also in the same section of 108 itself, because it starts from clause A till it goes till Q. So there are other rights and liabilities also, which we will look into the next in some other videos, but I'll just tell you what are the other rights and liabilities. So one of them becomes the liability as of a lessee's consent is to pay rent. You are enjoying the possession of the property, you are retaining in the property, you are enjoying the property, means you have to pay the rent also. So it can be a premium, or it can be a money part paid, or a part promised, or it can be a share, or it can be crops grown, and also it can be anything as per the definition which we have studied under section 105. It can be of any nature, but you have to pay the rent as agreed upon, and to restore the property leased in good condition. So we have seen that you have to give back the property in the same condition in which you have received the same from the lessor, in the same good condition in which you have received the property from the lessor, and not to commit waste. You cannot destroy the property, you cannot commit waste in the property, you cannot destroy the nature of the property. So let's say if it's an agricultural land, you cannot just like that put waste in the property and destroy its nature itself. So such things shall not be done. Such things shall not be done by the lessee. And not to erect any permanent structure. So without the consent of the lessor, you cannot erect any permanent structure in the property. You have to get the consent of the lessor. So lessor consent becomes paramount when, as of the erection of permanent structure is concerned, because when you erect something permanently in the property, then while going or when the lease period comes to an end, it does not becomes that easy to remove the structures easily. So when it is a temporary structure which you have done, then it is fine. But whether law totally prohibits it, it's a no. You can do so provided you have an agreement. You haven't. It's always better to have an express contract itself. To put it in words, you have a contract, then it is fine, no problem. No one can there will be no problem in the court of law also. That prevails, because we have studied this contract to the contrary. So if a contract is there, if a local custom is there, if a usage is there, if an agreement is there, that prevails over these rights or this law. Those things will be followed, provided those are lawful. So having this condition stating that the lessee can have a permanent structure in the land, then it is fine. There is nothing illegal in that. Okay, so likewise this you have to make sure that most of the things as a property law is concerned, it's always better to go with an express contract rather than an implied one, though there are certain exceptions given, like you can have an implied as such also, or you can have an implied contract also, but it will be always a safer side when it comes to the intervention of the court, or the when you go for the judiciary and all, then it's better that you have an express contract to easily prove yourself, your point of view, and to deliver the possession on the expiry of term. So we have seen that you have the right to get the possession, and it becomes a liability of the lessor to give you the possession. So it becomes a rights of the lessee to claim the possession. Now it is a liability of the lessee to give the possession back. You have to give the possession back on the expiry of the term. So on the expiry of the lease period, on the expiry of the lease deed, the lessee is responsible. The lessee is responsible. The lessee is duty bound to give back the property, to give back the possession in the same way in which he has received it. So if you have erected anything permanent structures, you have to remove any temporary. So these things depends. These things depends on the parties, how they have agreed upon. Like it can be as such, or you have to remove everything, you have to give it back and all. So let's say even if you're going for a house, and let's say when you're going, he has painted it, he has done all the uh, paint and all for the property. So when you're vacating, you have to give it back in the same condition, which is not possible, because a normal wear and tear will be there. Let's say you're there in the house for 2 to 3 years, a normal wear and tear, there will be lots of scratches and all in the property. Now you have to repaint it and give it to him, or you can just give that particular amount which is which will be required to paint that particular house, and then only you can come out. So this also depends on the terms and condition. So it's always better that if you're thinking of some terms and condition as of a lease or as of a sale or as of any rental agreement, it is always better that you put it in words itself, you put it in the contract itself, you make it as an express contract, you express your opinion, you express your thought, and when both the parties signs, then there is no problem. He has to agree upon it, he has to, he's duty bound to do so, because there is a contract which is enforceable in nature. And to avoid the lease when the property is destroyed, so as I said you that you can also avoid the lease when the property is destroyed. So these are the certain rights and liabilities as of the lessor is concerned. So in the usual terminology, you would have come across the lease being for a period of year, like let's say only for 1 year or 2 years or 3 years, but even a lease can be for 99 years also. A lease is legally valid if all the terms and conditions, if there is a written contract and all, it can be there even for 99 years also. There is no problem on that part, provided you put all those terms and conditions and all, and then you can go with that. So students, thanks for your patient listening. We will meet in some other video lecture. Thank you.